Marius, good to talk to you. Let's talk about the reasons given by Judge Makaula to recuse himself. Is he taking the initiative here before he's pushed?
Yeah, I do believe the last thing you want, Tony, is for the trial to continue, to have all the witnesses in the matter testify, and then at the end of the day, when the matter comes before another court on appeal, to have the appeal court say, well, listen, it's clear that at the end of the day, justice was not done because the judge was compromised, because the witnesses were staying in his house and these facts were perhaps elevated or mentioned at a later stage during the trial. Then that's the last thing you want, because then the trial will be set aside and it will be ordered to start de novo. So if there's an indication that the trial should start de novo, or if there's a reasonable apprehension that there could be biasness on the part of the judge, then the sooner rather than later the judge can recuse himself is the better. So in this instance, I believe that you might be right, Tony. Before he's pushed, it's wise to fall on your sword, especially if you know that the witnesses stayed at the guest house where your wife had interest in. That might not be wise.
Okay, so what are the implications now for the Omotoso trial?
Well, the sad thing is, Tony, that means the trial may start de novo, afresh, as though it hasn't started at all. So a new judge will preside in the matter. The same prosecutor, the same attorney will preside in will defend and prosecute. And then the same witnesses will be asked to take the stand again. And they might be cross-examined again. But there is, of course, provisions in the Criminal Procedure Act that says that, listen, if there's evidence that the state and the defense agree upon, they can have any portion of a record admitted. You can admit the contents of a previous record under Section 235, so that's possible. You could even say, listen, these aspects in the evidence is admitted in terms of Section 220. So there are various sections open that could be utilized in trying to say the defense will have a second bite at the cherry, so to speak, because then they'll have the opportunity of cross-examining the same witness on the same issue. The only difference is hindsight is an exact science. Now you're able to dissect the evidence that she has given, and you can now say, listen, I'm going to nitpick and focus on this issue. So it's definitely prejudicial to the state, but rather now than later.
That's what I wanted to get to, because, you know, in layman's terms, who does this benefit the most now? Surely it's the defense.
Absolutely, Tony. You know, the defense, like I said, has got a second bite at the cherry. So definitely it would mean that the witnesses that have testified will have to be cross-examined again as though they haven't testified. So that, of course, plays into the hands of the defense. But let me say this, Tony. If this was done 10 witnesses later, the damages to the state case would have been immense. So if there's any possibility that the judge has to recuse himself because there's a reasonable apprehension of biasness on his part, then you'd expect the judge to withdraw sooner rather than later. And let's just be honest, this judge has been challenged a number of occasions during this trial to withdraw. I mean, they even took him on appeal in certain instances where he refused to do so. But these factors that now came to light, of course, made him understand that his brothers, being the judges on appeal, when they perused this matter on appeal, they might feel, well, listen, you know, you knew you were tainted, you knew witnesses were staying in your house or in your guest house where your wife has an interest, and that definitely plays into the hands of the defense, and we have to say, you know, the matter should be set aside. So it's maybe wise by the judge at this stage. I do think it's wise, but it's definitely prejudicial to the state.
So now we might get Cheryl Zondi back in the witness on the stand again. We saw how emotional she was. We saw what happened in terms of the support she got throughout the country. Why put the witnesses through all of that again? I'm sure the new judge now will take a look at that, and that has to also be top of mind for him.
Yeah, the difficulty is, Tony, that, you know, those observations of how emotional she was, the observations of how she testified, the observations of how she acted in the witness box, those observations are very important at the end of the day when a court looks in the totality of the evidence at the credibility of witnesses. And that, if she doesn't testify again, the court will not have the benefit of that. And the judge would be asked to read a bunch of papers which is a transcript of her evidence, and asked to just judge based solely on the transcript. So you'd lose a lot in the process. And that's why often on appeal the judges loathe to interfere with factual findings. They will do it, but they they know that the judge who presides over the matter is essentially in the best possible position to make a call on the credibility of witnesses than anybody else. And for that reason, you'd want to say that Mrs. Zondi would have to testify again. She would have to go into the witness box. And I understand it's traumatic. I understand it is terrible. And that's perhaps one of the reasons why we sometimes have the witnesses will not do something like this again. They might say, well, I don't want to testify. I'm sorry. I'm not prepared to put myself emotionally through that again. And, you know, that's why I said in the beginning, Tony, this plays into the hands of the defense. Keeping in mind they've already applied twice to have the judge recused. This is now the third time lucky for them perhaps. And they might feel that, listen, we're going to have a second bite at this. And they might feel, at the end of the day, this absolutely plays into the hands of the pastor who's being charged.
Marius, if, let's say, Ms. Zondi or any other witness testifies, but somehow the testimony is not exactly the same as what you testified the first time around, can the defense refer to when she took the stand the first time around?
The defense would be extremely ignorant and poor if they do not have the record transcribed of the evidence of Ms. Zondi. And when she testifies again, Tony, without a doubt, they would dissect the new evidence in comparing it with the transcript of her first opportunity when she testified. And if they are, remember, not all discrepancies are material, but if there are material discrepancies, you'd expect them to point it out to her and say, well, ma'am, you testified earlier X. Now you're testifying Y. Which is it? What is the truth in this instance? Why have you changed your evidence? Because if you're telling the truth, why would there be a need to tell a different story? So you would expect a witness that's honest and truthful to stick to a story. But Tony, without a doubt, if I'm the victim, I would not be pleased with this development.
Okay, so Marius, I just want to recap one thing, is that the witnesses who testified the first time around, they can refuse to testify this time around.
Well, Tony, that's a difficult one. You know, a witness can only refuse to testify if there's very good reasons to do so. You can't just say for the sake of, I've now been subpoenaed, now I don't want to testify because I don't like it, now I'm not going to testify. But if the witness has, let's assume for one moment, Ms. Zondi can convince the state that she, as a result of the first time around, she suffered severe emotional trauma, she's unable to testify further, well, then the state honestly has to look at that because, you know, you can't blame her for that. She took the first opportunity to testify and now she has to do it again. For her to, if there's no basis like that available, and she just says, I don't want to testify the second time around, she could be arrested and brought before a court to testify. You can force a witness, because remember, she's now a witness for the state. And as a witness of the state, she's competent and compellable, which means that she can't really refuse unless there's exceptional reasons to do so. Well, maybe not exceptional, but unless there's good reasons to do so. Maybe on medical basis, maybe on the trauma she suffered the first time around. But otherwise, she'd be compellable to testify. And if she doesn't do so, and she now refuses to testify, and she maybe testifies something different, she might even be declared a hostile witness, heaven forbid. But I don't think we are there. I just think that the state would obviously sit down with her, they would spend time with her, they would explain to her the importance of her evidence, the importance of telling the truth, and just, you know, unfortunately, this is an unfortunate event, we must put it behind us, and we must get her to testify, because ultimately, if justice has to prevail, Tony, she has to testify again. Otherwise, it's going to cause a ripple effect for other complainants who think, well, you know, maybe I shouldn't complain, maybe I should keep quiet. And we know in our country, gender violence is a massive thing.
Yeah. All right. Thank you so much for clarifying a lot of that for us. That's legal expert Marius du Toit talking to us from our Pretoria studio.